one more bill before we get to the star of the show here, Representative Cortrafront. Let's see, it's Chairman Shanley's bill. I'm putting it in because he's otherwise occupied as a babysitter at home. And it's an act related to criminal procedure, county grand juries. It permits grand juries to issue reports and provides for a process for review and acceptance by the Superior Court for dissemination to the public. And here we have several witnesses, but I reached this because we have Deputy Attorney General D. Goldstein here, and you could take the rostrum and inform us.
Thank you very much, Mr. Chairman, members of the committee. This is the third year that the Attorney General's office is proposing this bill. This bill would amend the grand jury statute to allow for the issuance of grand jury reports in certain cases. Under Rhode Island law, as you all know, grand juries have the authority to investigate crimes and return indictments. However, aside from returning indictments, they have no mechanism for reporting on their findings. And furthermore, rules of criminal procedure are very clear with respect to grand jury secrecy and the confidentiality of grand jury records. Our research indicates that there are a number of other states, including New York and Pennsylvania, which perhaps are the most well-known, that allow the grand juries to issue reports in certain circumstances, with notice to the named individuals and a number of very important procedural safeguards that are imposed by the courts. This bill would allow statewide and county grand juries to issue reports pursuant to the following process. They are to be submitted only with the consent of at least 12 grand jurors, the same number of grand jurors required to vote to bring an indictment. An individual or entity that is named in the report would be notified in advance of publication and given an opportunity to respond and to object to the release or to seek a redaction. Those individuals would also have the right to appeal a court's decision with respect to release or redaction, as would the Attorney General's office if the court chose not to allow the issuance of a grand jury report. The amendment also contains a bunch of procedural safeguards that the Superior Court justice would have to be satisfied are met prior to authorizing release of the report, including that the grand jury was properly convened, that the facts in the report were revealed in the course of the grand jury proceedings and are supported by a preponderance of the evidence, the same standard of proof used in civil proceedings, that the report does not contain personal materials that is unrelated to a lawful grand jury inquiry, that it does not disclose certain confidential information, like confidential informants, and that the release of the report does not prejudice fair consideration of any criminal matters. Simply stated, there are times when the grand jury does not return an indictment, does not find that there is reason to commence a criminal prosecution, but has arrived at certain conclusions or findings that would be in the public's interest to learn, and it would be in the public's interest to understand what has happened. And I think we can all come up with some examples where that could be the case. For example, officer-involved shootings or police use of force cases, cases involving institutional misconduct, potentially cases involving public corruption. These are all instances where potentially there are no criminal charges that could be brought, but there is a great public interest in learning what has happened. And this mechanism would allow for transparency that would promote public confidence in the process. It would promote public confidence in our criminal justice system and in the grand jury process in particular. And therefore, we believe that this is an important tool that has been properly used in other states very selectively. There is a sunset provision that could be an important tool for transparency and for public confidence in the system and would benefit the public with all of the safeguards that are in place right now. Thank you very much, Mr. Chairman. I'm happy to take any questions.
Any questions? Let's start with Minority Leader Blake Philippi.
Thank you, Chairman. Thank you, Attorney Goldstein. It's good to see you
afternoon.
again.
Good to see you as well, Leader.
Thank you. Would the grand jurors be subject to any type of defamation claims by a target of a report?
I don't believe that they would, Mr. Leader. Again, this report would only be issued with the authorization of the Superior Court and the presiding justice. And I think that is a very important protection. Otherwise, grand jurors, just like the attorneys that appear on behalf of the Attorney General's office before them, grand jury reporter are bound by rules of grand jury secrecy, and they would not be permitted ordinarily to speak about anything that happens before the grand jury.
So they have some element of privilege protecting them from
Correct.
claims by defamation of a
Correct.
target, so that in a way it makes a target not have the ability to seek justice, if you will, if they were maligned in a report inaccurately.
Well, again, I think that the way that this is contemplated to work is that the grand jurors would only be permitted to speak through a report. That is the mechanism for a grand jury to issue their findings. That report would have to be approved by the court, by the Superior Court judge, perhaps with redactions, perhaps with, certain things omitted, or names redacted, for example. And that is the process during which anybody named in their report could voice their objection and be heard, and then appeal.
Understand. And if all of that is unsuccessful,
Correct.
they wouldn't be able to file some type of action to
That's my
seek
belief.
monetary compensation for
Correct.
defamation. I mean, I support the bill, there's never a
That's a
perfect
good
bill,
question.
you know?
Yeah, thank you. I appreciate it.
I appreciate
I
that,
think
Attorney
our grand jurors, having appeared many times before federal grand jurors and some state grand jurors, they are good people. This is a very old and venerable institution, 23 Rhode Islanders. They take their job really, really seriously. They work very hard every day. So I thank them again on behalf of the Attorney General's office and the people of Rhode Island for everything that
I
they
think there's
do.
one more question over here from Representative Batista.
Good afternoon. Thank
Good
you.
afternoon,
Good
Representative.
evening, probably.
Still sun.
I have two quick questions for you. One, I noticed there's a sunset provision, July 1, 2027.
Yeah.
I read that to mean that this bill would essentially go away at that point. Is that the case?
It would, unless obviously the General Assembly chose to remove that sunset provision and extend it.
Can you tell us a little bit about why that was placed in there?
Yeah, I think that there was a sense when we were talking to people about this bill, because it is, it is perhaps a significant expansion of the grand juror's power, and it is significant change to the law. I think that there was some concern about what it would mean, how it would be used, and they felt that a sunset provision would be an appropriate safeguard. But again, this is all stuff that we would be happy to talk to members of the committee about.
And my second question is, you referenced other, I'm sorry, can I have a second question? You referenced other states that have this. Can you speak to maybe how many states? Is it like a majority?
Sure.
Is it only a few? And are there examples of good things from a public policy perspective that have happened in other states? Or conversely, has anything bad happened as a result?
Sure. So our research indicates that there are 18 states that have grand jury report provisions. Actually, the federal government also has a grand jury report provision. I believe that in all of these states, this is a tool that is used pretty sparingly. And so the states that we have particularly looked at are New York, Colorado, Pennsylvania, California, Oklahoma, and Washington State. Those are states that have, pretty robust laws in place and have used them. I think one of the most famous cases where there's been a grand jury report is in Pennsylvania, where they issued a report on the diocese. And that was in connection with a very broad, long-range investigation that the grand jury there conducted. They returned, I believe, 3 indictments against priests, but the grand jury also issued a much broader, wide-ranging report that, I think resulted in some law changes to the law and was very informative to the public. More recently, actually, I think also in Pennsylvania, there was a grand jury report issued in connection with an investigation into fracking practices by a number of energy companies. And again, I believe that there were indictments returned with perhaps particular individuals or companies, but the grand jury there found some information that they thought might be useful to the public to understand about fracking practices. And so a report was issued on that. Sure.
Yes, Carol.
Thank you, Mr. Chairman, and thank you, Ms. Goldstein. This is a good bill, and I'm glad you referenced what happened in Pennsylvania, because that was very eye-opening, that report. And although several of the names of the people were redacted, it did give the public knowledge of what was going on with the Catholic Church in Pennsylvania over decades of time, and it proved to be very worthwhile for the public to know how deeply entrenched the problem of childhood sexual abuse was within the Catholic Church at the time. So I want to thank you for bringing this bill. We've heard it several times, and hopefully this is the year. But I think there's enough protections for persons who aren't being charged and won't be named, but the issue that a corporation or a large group is involved in is very compelling, and the public has a right to know. And it also, like you said, it was very instrumental in changing laws in Pennsylvania that, you know, helped us as legislators could use that information to say, if there's a broader problem, maybe we need to address it, and how do we address it? So thank you very much for coming, bring this bill once again.
Thank you very much, Vice Chair McEntee. Appreciate it.
Deputy, thank you very much for your
Thanks.
assistance.
Thanks, Mr. Chairman.
And we'll move on.
Okay.
Thank you for coming.